Chahowski,
Yes.
you're supposed to be here in person. Why are you not here?
My letter tells me it's Zoom on 6/22. Letter tells me.
I'm looking at the notice that was sent out.
All right, I
So
have
there was
right,
so,
I have it right here in front of me.
Mr. Chahowski,
Yes.
your original letter that was sent out on March 23rd said that it was to be via Zoom. Another letter was sent out on May 13th because instead of a review, it was going to be a violation. And that violation was changed to be a hearing in court. And Mr. Marana tried to reach out to you regarding this and was unsuccessful. So did you not have the right contact information?
So I did not have any good contact for him. I have emailed him and he has scheduled to appear for appointments on May 23rd and June the 7th as well. So I've had no contact with Mr. Chahowski for.
When's the last time you had contact with him?
Last time we had contact was May the 9th.
So, Mr. Chahowski, how did you think probation was supposed to go? Did you think that you just checked in when you felt like it?
No, not at all. I understand my civic responsibility. That's why I'm with you. That's why I'm with you here today. Your Honor?
Yes.
I'm in the process of moving, and I've changed locations. And since I moved locations, my email has been locked.
The hearing opens with the judge immediately questioning why the defendant is not physically present in court. The defendant relies on an outdated notice claiming the appearance was meant to be virtual. The judge clarifies that a second notice changed the proceeding to an in-person violation hearing and establishes that attempts were made to contact him. This sets the tone early. The issue is not confusion, but failure to keep up with court instructions.
Through my email. And I'm dealing with that right now.
Well, is your phone number the same?
No, I got to.
When you change address and phone number, don't you think it would be a good idea to make sure your probation officer knows that?
Well, I think it's a good idea, but you got to understand I've been dealing with my father's death that I caused. And I've been dealing with cleaning out the house, and I've been trying to find an apartment. Yes, I understand that, and I do understand my civic responsibility. I do, this is the first contact that I've gotten at this location, and I'm happy to give my phone number and my address to my probation officer.
Here, the discussion shifts to probation responsibilities. The defendant admits he changed both his address and phone number without notifying probation. The judge calmly explains that maintaining updated contact information is a basic requirement. The defendant offers explanations involving relocation and communication issues, but the court emphasizes that responsibility lies with the individual, regardless of personal inconvenience.
Mr. Chahowski, I need to see you in person, so I will adjourn this 1 week. So it will be set again a week from today. At the same
Why
time.
do you want to see me in person? I don't know if I can go down there. I'm not sure if I can do that. I don't have a driver's license. I cannot drive. I can't be going any place. You know, my license is restricted. So I'm not really sure whether or not, and I'm not sure the reason you want me down there. For what reason? To put me in handcuffs and put me in another 44 days.
This will be real simple. I'm just gonna. I want to make sure you can hear me, okay? And I'm a little concerned at your tone.
Well, I'm a little concerned about what you're stating. I'm a little concerned. You want me down there for what? For what reason?
Okay, so I will note today that Mr. Chahowski was aware that he was supposed to be here today. Mr. Chahowski has indicated that, oh, hang on a second. Mr. Chahowski, can you hear me? Mr. Chahowski, can you hear me?
Yes, I can, officer, or honor.
All right, this is real simple. I'm indicating to you right now that it is the order of this court that you present yourself to the court a week from today. Are you telling me
Your Honor, I'm not going to court. I cannot get there. All right? Period. Yeah.
The judge orders the defendant to appear in person the following week. Instead of acknowledging the directive, the defendant questions the court's motives and expresses fear of being jailed again. This moment is critical because it marks a transition from misunderstanding to direct resistance. The judge makes it clear that appearing in person is not a punishment, but a standard legal requirement.
How did I? What? Your Honor, what did I do? What did I do?
Mr. Chahowski, I'm
Yeah.
happy to explain it to you. You have failed to appear for probation appointments.
No, I did not. No, I did not. I told you why I didn't.
Boy, that escalated quickly. I mean, that really got out of hand fast.
Listen to me.
All right, Mr. Chahowski, I'm not gonna tolerate you speaking to the court in that tone. You failed to appear today. You've indicated, no, Mr. Chahowski, I've hit you on mute. I have nothing more than I need to hear from you. I've indicated to you that you have 1 week from today to appear at the court. If you're not here a week from today, then you're absolutely right. You will find yourself in a jail cell a week from today. If you show up a week from today and perhaps explain to me what's going on with you in a manner that's respectful, he's not listening.
No.
That's unfortunate.
Tension escalates as the defendant explicitly states he will not come to court. The judge responds firmly, explaining the legal consequences of refusing a court order, including possible incarceration. This clip highlights a clear cause and effect moment. The court lays out the consequences in plain terms, leaving no ambiguity about what will happen next.
So, Mr. Chahowski, I'm going to adjourn this violation for 1 week. I'm going to adjourn this violation and it's going to be in person. Now, during that week, I am inviting you to reach out to your probation officer because nothing is etched in stone. Your last experience where you went in person to court, you did 30 days, okay? Now, you are not in compliance with probation, but that doesn't mean that I automatically go to the consequence of a jail sentence. Because I know, Mr. Chahowski, that with you, there are also, there are many different challenges, including some mental health challenges that you try to work through. And I know that your rage at the court right now and inappropriate behavior today is a byproduct of fear and a byproduct I know there to be a significant mental health challenge. So I am willing to wait and pause and give you a week to respectfully reach out to probation, understand why you're in violation, try to see if you can correct those violations and come up with a plan outside of the jail setting. I am at least willing, even now, to consider those opportunities. I have not made a snap judgment about you, Mr. Chahowski. I have not come to the conclusion that you are unredeemable or that you need to do 93 days in jail. I simply ask that you not make a snap judgment about me or my probation department. Everybody here is required, wait, I will unmute you in a second. Everybody here is required to meet certain standards. You are here for criminal behavior that needs to be addressed. I know when your mouth is open, sir, that you're not listening to me. I know when your mouth is open, I will unmute you and you can make some comments in a second. All right? But I know when your mouth is open, you're not hearing me. You made an assumption. You've made an assumption that I'm trying to figure out a way to put you in jail. All right? I'm simply trying to get you to come here as anybody else who has a violation. Everybody else who has a violation is here today in person. Everybody else. I don't have a special set of rules for Daniel Chahowski. You have to meet the same set of rules as everybody to unmute you, sir, right now. But just recognize that although you are not present in court, in court as far as in person, you are still in a court setting. You are still in a court setting. So if you are disrespectful, rude, if you are If I unmute this, sir, and you use language that's inappropriate, I can find you in contempt of court and sentence you to jail. Yes, I can find you in contempt of court. Let's see what happens.
Defendant becomes argumentative and interrupts the proceedings. The judge shuts this down decisively, stating that disrespectful behavior will not be tolerated. This clip demonstrates courtroom authority in action, showing how quickly a hearing can turn serious when boundaries are crossed.
I've allowed you to unmute.
I'm on unmute. Can you hear me?
I can hear you.
All right. I spent 44 days in jail at Macomb in Oakland County Jail. During that time, I contracted COVID-19. I was released, and my father caught COVID-19 from me, and he passed away. So, do you really believe jail sentence is the right alternative to go in this pandemic that we're having right now? Is that what you feel it is, or are you not concerned with that?
Mr. Chahowski, there are many precautions that are put in place right now, and so
No, there's not. No, there's not. There's no precautions. You got to straighten out your.
Here in a week, then you guarantee yourself a jail sentence. If you're here in a week, then maybe we can talk about alternatives. Maybe we can talk about alternatives. I'm happy to have that conversation.
All right, Your Honor, I will contact my probation officer, but I won't be there in a week, and I want that down on record.
Okay. And Mr. Chahowski, I want to make sure it's also down on the record that I advise you fully that if you're not here in a week, that a bench warrant will be issued for your arrest. This conversation is over.
In the final critical segment, the judge shifts tone and acknowledges the defendant's mental health struggles and past hardships. Instead of immediately imposing jail time, the court offers a 1-week pause to allow the defendant to contact probation and attempt compliance. The judge makes it clear that this is an opportunity, not leniency without limits, and that future cooperation will determine the outcome.